There are a number of cases where employers dismiss employees because the employee has been seen or witnessed doing something which the employer thinks isn't right for the employee to do while off sick. But there are some times where the employer's actions are deemed unfair, particularly where the employee is dismissed in these sorts of cases. In one example, there was a driver who was dismissed from his job after the employer had witnessed him at a pub. And in this particular scenario, the employee was off ill for some time, he was off work, and he had a disease called chronic obstructive pulmonary disease. And this meant that he had to have a period of time off work. He was, however, seen by the company's manager smoking at a pub. He had actually called the morning beforehand to tell his employer that he wasn't able to go to work because he was that bad in bed all day with his chest. And then the employer had seen him the following day. He had actually later denied being in the club on the day in question when asked by the employer. The employer therefore just dismissed him. And although they had a disciplinary hearing, the tribunal found that the disciplinary hearing had left much to be desired. In particular, part of the facts that were put to the employee that he had been seen several times drinking and smoking at that particular club while he was off work, and told that surely if he was unfit to work and on antibiotics, he should be at home and in bed. The employer had dismissed him because they found that there was a breach of mutual trust and confidence between the parties, and therefore the claimant brought the claim that he did for unfair dismissal. The judge had found that there was nothing in the disciplinary policy or in the procedure to stop to say that an employee should not be out and about or at a pub, for example, if they're off ill, and that there were also flaws in the firm's investigation process, in the company's investigation process. The tribunal actually in this case therefore found that the employee had been unfairly dismissed. So the employee had won his claim. The employee who was witnessed by another employee at a pub drinking and smoking when he had told the company that he was off ill. What do I think was a major flaw in the design here? Well, I think part of the flaw was the investigation process and what was put to the employee. But equally, employees need to be mindful, and employers need to be mindful of the fact that just because an employee is off ill doesn't mean that the employee cannot partake in hobbies or socialize. It depends on what the illness is, it depends on what the fit note says, and it also depends on so many other facts. So employers need to be careful that they make succinct and really careful decisions along the way before they even think of dismissal. And employees need to ensure that if you are going to be saying that you're off ill, make sure that if you are going to be doing something that you could potentially be seen for, that whatever that is reasonable in the circumstances. You're welcome to get in touch if you are either an employer or an employee in this particular situation. Details are on the screen, and I look forward to hearing from you. Thank you.